This case comment is based on Samantha Scott's article published in 2010 in the Educational and Law Journal titled "Sometimes an Accident is Just an Accident." The case we're going to discuss is Hamilton versus Delta School District number 37. The incident that prompted legal action took place in a grade 11 physical education class where a student suffered a broken nose while playing floor hockey. The plaintiff alleged that the injuries were caused by negligence and held the Delta School District responsible. The points that they made were that the students were allowed to play floor hockey without the proper safety equipment, that the students were playing without proper supervision, and that they were playing without proper training. The plaintiff was interviewed by the courts and highlighted three specific things as evidence of negligence. The first being the particular game that was going on was excessively aggressive. The second, students were using wood sticks they had brought from home rather than using school-provided sticks that were plastic and safer. The third was that the supervising teacher was playing goalie on one of the teams. The courts found that the plaintiff's testimony lacked credibility. Her account of the incidents contradicted that of several other students that were interviewed, as well as the teacher's testimony. The courts accepted the testimony of several other students. These students claimed that the teacher was in fact not playing goalie during the time of the incident, and that only plastic sticks were being used during the game. The courts also accepted the teacher's testimony, claiming that the student had been trained in multiple phases previously in grade 10. Also, the teacher had provided a lengthy lesson on safety and rules at the start of the floor hockey unit, and also that this teacher had provided a summary lesson at the start of each class. Also to note, this was the third time they had played floor hockey, and the previously ones had no other incidences. After reviewing the evidence, the courts determined that Delta School District was not negligent in their actions. Students had been provided proper training, had been provided proper safety equipment, and had proper supervision during their floor hockey activities. As a result, the district was not held liable for the plaintiff's injuries. The underlying concern that's highlighted in this case is defining what is negligence and also how are educators protected from liable lawsuits. The Alberta Teachers Association highlights four elements that must be present before negligence is established. The first is that the plaintiff has suffered some damage. The second is that the damage was caused by some act or omission of the defendant. The third is the act or omission was one that a reasonable person behaving with ordinary prudence would not have committed. And the fourth is that the defendant has a duty of care to the plaintiff with regard to that act or omission. These definitions by the ATA bring forth some subjectivity when dealing with negligence in a legal framework. McKay and Sutherland also note that the court system has not added any clarity to it. In fact, the precedent set is something called the standard of care. And the definition of the standard of care is that of a careful parent. That in itself poses subjectivity and lacks clarity for teachers. McKay and Sutherland go on to explain that the lack of clarity in the definition of standard of care makes it very difficult for lawyers to predict the outcome in negligence cases. This makes the review of negligence very worrisome for educators. However, there are built-in safeguards that protect teachers from this sort of litigation. The Alberta Education Act, Section 54 states that a board shall, in respect of its operations, keep in force adequate and appropriate policies of insurance for the purposes of, at a minimum, indemnifying the board and its employees and school councils in respect of claims. Individual school boards are then required to have insurance that protects its employees from this type of litigation. Blackgold Regional School District has an Administrative Procedure 530 that demonstrates who is responsible for getting the insurance and who is covered by it. What this means is that teachers can be named in a negligence case. However, they cannot be held personally liable. What we've learned is that negligence cases are complex and unpredictable. But when teachers follow their professional obligations and their due diligence to keep students safe, sometimes an accident is just an accident.